Welcome, ladies and gentlemen, friends, colleagues, students. In this lecture, we are going to discuss the other interests of land that one can acquire per the statute that was discussed from the beginning of our lessons. That's the Act 1036, the Lands Act of the year 2020. You remember that in the other video, we discussed about the allodial interests in land. That is, if someone wants to acquire land in Ghana, or the nature of interest we have in Ghana, the highest and the ultimate is the allodial. In this section, we are going to discuss the other kind of interest in land, the one that we call the usufructuary interest. Usufructuary interest. What is the meaning of the word usufruct? Now, the word usufruct comes from the Latin word. It's a hyphenation or a combination of two Latin parts, the usus and the fructus. Usus to mean to use, fructus means enjoyment. So basically, when we talk about usufructuary interest in land, it means the interest that people acquire in land for purposes of enjoyment. Now, again, to help us understand what the statute, what the Act of Parliament has got to say with respect to the interest in land that we call the usufructuary interest, we once again turn our attention to Section 5 of the Lands Act. Now, notice that in this video, we are going to discuss the interest, the usufructuary interest, along two lines. How someone can acquire usufructuary interest, or the nature of a usufructuary interest, if the person is an indigen. And the other part, if the person is a non-indigen, or what we call a stranger, what is the nature of the usufructuary interest or rights that the person will have? Without much ado, we turn to Section 5 of the Lands Act 1036 to see what usufructuary interest is. Section 5.1 mentions, usufruct is an interest in land which is acquired in the exercise of an inherent right by a subject or a member of a stool or skin or family or clan, which holds the allodial title through the development of an unappropriated portion of the land, of the stool or skin or family or clan, by virtue of an express grant. So you saw what the statute said in Section 5.1a about the usufruct. Three things were very clear from the nature or the writings that we find in the statute. It says that if there is an unappropriated land, and this unappropriated land belongs to a stool, a family, a clan that has an allodial title, if a member of that family, stool, or clan who has the allodial title, if that member proceeds to develop an unappropriated portion of the land for his own use or for his own purpose, he acquires what we call a usufructuary interest in it. So essentially, we are saying that if someone is a member of a stool, a subject of a stool, and the stool has an allodial title, there is an inherent right, a natural right that comes with the person being the subject of the stool, to have also for his use a certain portion of the land. Therefore, if, for example, you come from an area, let's say we call it Kukumpe, for the purpose of our discussion, and you are subject of the Kukumpe stool, if there is any part of the lands that is within the jurisdiction or right of the Kukumpe stool, and you decide to go and develop that portion, as long as it is unappropriated, there has not been a decision or a plan to use it for some other state or some other stool-sponsored purpose, that particular land that the person develops or that you will develop in Kukumpe, you acquire a usufructuary interest in it. You understand that? Now, in an old case, the one that we call the Ohimi vs. J, that was determined by the West African Court. That was the court that was in existence before the formal constitutions of 1960 came. In Ohimi vs. J, a very notable statement, an instructive statement, was mentioned about the nature of the rights to land, or the nature of usufructuary rights that subjects or indigens of stools or clans that have an allodial title can express relative to land. Let's take the quotation from the Ohimi vs. J case. The court, in laying down the connection of subjects to stools or lands or usufruct, mentioned as follows: the subjects are entitled to the beneficial interest or usufruct thereof, and have to serve the stew. Each individual or family is regarded in the broad sense as the owner of so much land as it is able by its industry or by the industry of its ancestors to reduce into possession and control. The area of land so reduced into lawful possession of the individual or family, and over which he or they exercise a usufructory right, is usually called property. You notice what the court said in Ohimi vs. J. So if there's a person or an individual who belongs to a clan, a stew, a family that has an allodial title, and there's a portion of the land that by means of his own industry he is able to reduce into possession and control, that portion becomes his property. Okay, he acquires usufructory right in it. Basically, we are saying and reiterating for emphasis that an indigen will acquire a usufructory right over a piece of land or a portion of an unappropriated land if he is able to reduce it to his own control or possession or by his own industry. Now, in a very old write-up by R.S. Rattray, you know, Rattray was one of the earliest sociologists who wrote about the account culture. Much of the principle he mentioned in his book, Ashanti Law and Constitution, has got much of significance and relevance to the way usufructory rights are perceived in Ghana's legal order. In Rattray's book, he mentions that in the olden days, it was difficult for people to even farm. Why? Because the tall, difficult vegetation made it a bit of a challenge and an impossibility for one to conduct farming activities. Therefore, if an indigent, by his own industry, strength, and support of family members, was able to reduce a portion of that very difficult terrain for his own use, justice allows that he has the right to keep it. So the statement by R.S. Rattray in his book is of persuasion to us and helps us to understand what usufructory interest is. So when an indigent, a member of a stew, a clan, a subject, has been able to clear a bit of portion of land that hasn't been given to anybody, and he reduces it to his possession, he acquires a usufructory right in it. It goes therefore without saying that if an indigent acquires a usufructory right, the allodial title holder cannot dispossess him of that usufructory right. That is, the allodial owner, the chief, the queen, who sits as the occupant of the stew, cannot just move in there and decide to take that usufructory right away from him. In a sense, he cannot expel him from the land that the indigent has had in his possession and control. To this, we again refer to the Lands Act, Section 5, in continuation, when it mentions about the nature of this usufructory interest. The Act continues. Section 5C, speaking of usufructory interest, it mentions that it is inheritable and alienable. So Section 15C mentions that usufructory rights are inheritable and alienable, which means if an indigent who possesses a usufructory right over a land, he also reserves the right to pass that land onto his kinsmen or to his next of kin or generation. He can give it to his kids, he can give it to his nephew, he can give it to his nieces, he can sell it. That is it. So basically, that is what the usufructory right mentions. I want to emphasize again that because of the nature of the usufructory right, as we've mentioned in the foregoing cases, the allodial title holder would have no right to dispossess the usufructory owner of his rights over the land. Now, in this, we call to mind a very famous old case, not so old, somewhat decided by the Court of Appeal in the 1970s. The case is Mansu versus Aboy. This is what happened in Mansu versus Aboy. Now, the plaintiff who had brought this matter and further for further appeal was an indigent of a local community. He had palm trees that he had erected or planted all over. He was what we call a palm wine tapper. Now, the local chief, or Dodikro, who purportedly claimed the allodial title control over the space, entered into an agreement with another company. And in exchange or within the terms of the agreement that the chief had with the company had to go in and take over the land that was originally being occupied by this indigen of the stool. The matter went to court. And the apex court at the time, though it was the Supreme Court, the apex court at the time mentioned some very important statements that helps us to get a sense of what usufructuary interest is. This is what the court said in Mansu versus Aboy. Speaking by courts, it says that it was overlooked, referencing the decision of the trial court. It overlooked the fact that the land was ancestral property and palm trees could not, in that circumstance, be considered to be wild. They grew out of habitation. You saw what the court said in there. The court rested its judgment in part on the fact that the land was in possession by an indigen. It said that this land was ancestral property. The palm trees don't just grow out of the wild because palm trees are economic trees, which means that the land had been a subject of an economic activity by an indigen. So once the land had been a subject of an economic activity, you have had an indigen working on the land, planting palm trees on it, which don't just grow in the wild. That was a clear case of the allodial title seeking to infringe on the rights of the usufruct. And therefore, the court held that the allodial title holder, that was the chief, did not have a right to interfere with the possessory rights, the usufructuary interest, as we will say, of the indigen. The point is simple, ladies and gentlemen and colleagues. If there is an indigen, a subject of a stool, once the person can show that he's a subject of the stool and he has reduced any portion of the land into his effective control and possession, either by farming or some other acceptable practices, the allodial title will have no right to dispel the usufruct of his interest in it. Now, let's look at the second leg, what the statute provides. Now, we understand that if the person is an indigen, it is okay. He's a kinsman. He belongs to the stool. He's a subject of the stool. He serves the stool. Therefore, it can make a lot of sense that he cannot be dispossessed of his interest in the land. What about a stranger, a person who is a non-indigen? He is not a subject of the stool. In what sense can he acquire usufructuary interest on the land? Again, we refer to the statute of Act 1036. It goes on to help us to understand how a non-indigen or a stranger, as we'll say, could acquire usufructuary interest in a piece of land. Let's continue with our explanations from the statute of the Lands Act 1036. Section 51B, speaking again of usufructuary interest, says that it's acquired through settlement for a period of not less than 50 years with permission of the holder of an allodial title by a non-indigen or a group of non-indigens or descendants of non-indigen or a group of non-indigens, except where the settlement is on agreed terms. You saw what the statute said in section 51B. If a person is a non-indigen or he comes from a group of non-indigens, they are not subjects of the stool. They don't come from the town. They are foreigners. They are strangers. If they have lived on the land for a period of not less than 50 years, they acquire usufructuary interest on the land. We understand that? So if there is a foreigner who comes out on his sojourn or by any other means and settles on the land, though he is not an indigent, when he has resided on the land for a rather extended period of time, as the statute provides, he acquires the same rights as an indigent will have acquired on it. That is what we refer to as the usufructuary interest for non-indigents. Remember, the statute mentions that, or the law provides that, except by express grant. And the reason is simple. Because if there is an express grant to a non-indigent, then the continuous stay on the land for over 50 years or whatever does not necessarily confer him with a usufructuary right. It may, therefore, constitute a form of a lease, which we'll discuss in our later videos. So we are saying that there shouldn't be an express grant. If there's an express grant, then it means that there is a clear decision that we are going to give this land. The person doesn't acquire a usufructuary interest out of that. But now watch. It mentions that by permission. So how then do we reconcile the two ideas? The person was not given by an express grant, but yet we mentioned that he was given permission. From the construction of the statute, it seems to give the impression that the permission being mentioned in this statute is referring to some kind of acquiescence, some kind of a loose permission, a permission where the person has not necessarily been contracted, that there is no much of a contract of a sort. It's like we observe that the person is there, but we don't really challenge his existence, or we don't really challenge his stay or his subsistence on the land. That's the nature of the permission. Because it's only when the person has stayed there and you've looked on unconcerned for more than 50 years, he acquires a usufructuary interest in that. In a recent Supreme Court decision, this particular matter of a stranger having the right to acquire usufructuary interest on a land said that the nature of his rights can be protected just as an indigen would do, was decided in a very recent Supreme Court case. The case was entitled Togbe Lugu Awadali IV versus Togbe Gbadawo IV. The Supreme Court made a very important pronouncement relative to how a stranger or a non-indigen could equally acquire usufructuary rights over land. This is what the Supreme Court said in the case. Usufructuary rights are not reserved exclusively to individual members of the group or family or clan which communally owns the land in question, but they can be acquired by any person, including a stranger. A stranger can acquire usufructuary rights over land owned by another group or family, either on terms or through acquiescence. In the eyes of the customary law, such a naturalized stranger holds and enjoys an interest in the land, not as a stranger anymore, but as a subject with no limitations or restrictions attached to his enjoyment of the land. The Supreme Court made it very clear, as you saw in the quotation in the Togbe Gbadawo case. He is saying that it's clear. There is a situation where we can call someone a naturalized stranger. Who is a naturalized stranger? If the person, by means of an acquiescence means you've looked on, stood by for the person to exert and show overt acts of possession of the land, without you rigorously challenging that. Clearly, we are saying that that can constitute an acquiescence, or by some kind of agreement of a sort. So a stranger can acquire usufructuary interest. The statute has therefore put a lot of strength in this. If that kind of existence has been in place for more than 50 years, or at least 50 years, the person or the stranger has the rights just as a subject of the two does. We are fine. Okay, so now let's see the other bits of it. How then can someone alienate a land if he has usufructuary interest? If the person is a subject of a stool or an indigen who by prolonged stay on the land has also acquired such usufructuary interest, what is the legal provision, or what do the laws provide as to how usufructuary interest could be alienated? Again, we go back to the provision in the Statutes of the Lands Act, Section 5, subsection 2. Where alienation of the usufruct is to a person who is A, not a member of the stool or skin or clan or family which holds the allodial title, or B, is not a non-indigen or from the group of non-indigens who hold the usufructuary interest as provided in paragraph B of subsection 1 in the land in respect of which the usufruct is to be alienated. The alienation is subject to the written consent of stool or skin or clan or family or group and the performance of established customary obligations. The statute adds how alienation can be done. So if someone has a usufructuary interest and he's an indigen, by inference, he can pass on those usufructuary rights to another indigen. That does not need any consent from the allodial title holder. So if I'm an indigen and I decide to pass my usufructuary rights in a piece of land to another indigen, I don't necessarily have to go and seek consent of the allodial title holder or the paramount chief of the area. That is not the law. But the statute says that if the transfer of the usufructuary interest is going to go to a person who is a non-indigen, that is, you are going to alienate it to a non-indigen, then it should require a written or an express consent from the allodial title holder, followed up with what? Performance of traditional customary rights. So emphasis, I repeat again, that if an indigen, say I'm an indigen, I decide to pass on my land to another indigen, no hassle. I don't need any consent from the allodial title holder. That is okay. But the statute is saying that if the interest in land has to be passed on to someone who is a non-indigen, then it requires a concurrence by the allodial title and a recognition in customary sense. Some other practices have to be performed. So in some situations, maybe there has to be the giving of drinks. There has to be some other payments of some of a sort, any communal practices that are reasonable or within the confines of the law to suggest that the allodial title has concurred and agreed to the transfer to a non-indigen. Because remember, the land belongs to the allodial title. They have the ultimate rights on it. That right can never be extinguished. So if a person who does not come within the sphere of the allodial title's control, they don't exist in their jurisdiction, then there has to be a situation for the person to actually pay allegiance to the allodial title holder, recognizing the allodial title holder as the supremo of the area. And that is in part the reason why the statute provides that if the alienation has to go to a non-indigen, then the better thing that has to be done by the law is for that non-indigen to be made to satisfy all customary terms. Now, in most of these cases that the Supreme Court has recently cited about usufructuary rights, a very important Nigerian case was also mentioned. It's of relevance. Let's look at what was said in that matter. So in Tijani versus Secretary to the Government of Southern Nigeria, 1921, in the Privy Council, it mentioned, the owner of the usufruct title can alienate his said title without the prior consent and concurrence of the absolute owner, so long as the alienation carries with it an obligation upon the transferee to recognize the title of the absolute owner. The point is clear in the Tijani case. This case was cited with approval in the Tobik Badawu case and several other cases that has popped up. The point is this. Once the transferee, the non-indigen, who has acquired the land from the indigen, recognizes the allodial title rights of the allodial title holder, the transfer is fair. So guys, that is the subject of usufructuary interest. We've explained what the usufruct is, to use for the purpose of enjoyment. It can happen in two legs, the case of an indigen and the case of a non-indigen. What happens for an indigen? If he is a member or subject of a stool or family or clan that has an allodial title, he has an inherent right to any piece of land that by his own industry he has developed and reduced into possession and control, granted that that particular land or space was unappropriated. It is inheritable and alienable. He can pass it on to his kinsmen. He can pass it on in a will. He can do all that. He can alienate all it. And his possession cannot be interfered by the allodial title holder, as we saw in the case of Mansour versus Aboy. On the second half, if it is an indigen, and an indigen can also acquire usufructuary interest in the land. That is, if he has been in existence of the land for well over 50 years and counting, without any formal restraint by the allodial title holder, he enjoys the same usufructuary rights as a normal indigen will do. You cannot dispossess him of that particular thing. In alienation, we've mentioned finally that if an indigen chooses to alienate a piece of land to another indigen, he doesn't need any concurrence by the allodial title holder. However, if that particular land is used or rights has to be passed on to a non-indigen, then the concurrence of the allodial title holder is required by statute to make sure that it conforms with the laws of Ghana. That is the nature of interest of what we call a usufructuary interest. Let me hasten to add, for the purpose of your examination, if you are writing an exam, maybe your LLB course or you're preparing for your Ghana entrance exam, any law exam at all, you have to understand the nature of usufructuary interest. Why? Because it is key in understanding in contractual relations in land whether a person has even got a right to transfer a land to you or not. The foundations will be grounded on the usufructuary interest. Because if it is not a proper usufructuary title holder, then questions will definitely be raised as to the manner and form in which those particular interests in land was transferred to you. So you need to understand the root of title of your grantor. We'll discuss much of these matters when we reach the portion of our discussion on actions for declaration of title to land. But suffice to say at this point that apart from the allodial title interest, usufructuary title holders, it is also an interest in land that is recognized by Ghanaian law. Stay tuned for more of our discussion.